Hi everyone, I'm Dan Abrams, and this is Court Camp. We start things off in Racine, Wisconsin. Convicted felon Sean Reicher's in court for a pre-sentencing hearing.
You're gonna sentence me to life? Don't give a
Reicher was recently found guilty of 16 crimes against his family, including sexual assault and physical abuse of a child, as well as reckless endangerment. He's already served 12 years in a federal prison for detonating several pipe bombs in Utah. After his release, he moved his family to Wisconsin, where his abusive behavior included strangulation, beatings, and pointing a shotgun at his wife and children. It was his wife who eventually reported him to police. Today he's in court to waive his constitutional right to appear at his sentencing. And he's got company, a heavily armed security team. He's in shackles and a spit mask because he's already escaped once from a Wisconsin jail and has not been cooperative with court security. Once inside, the spit mask may be on, but gloves are off as Reicher wastes no time going right after Judge Wayne Merrick.
Is this your idea, Merrick? Huh? You got me looking like a clown? Stupid punk. Merrick. Get out! Here we go! Yeah! You! Get out!
When verbal abuse doesn't get a rise out of the judge, Reicher ups the ante with full-blown threats.
I'm killing all you Wayne. I got your address, Wayne Merrick. I got your home address. I got address. I got address. And I'm having you all killed.
The people he's referring to are members of the prosecution team.
There ain't nothing you're gonna do about it either. You know why? Because this is a state that doesn't have the death penalty. You're gonna sentence me to life? Don't give a Don't give a I'm getting mine, you
Not satisfied berating the judge, Reicher sends his wrath in the direction of the prosecutor.
Eat this up, Mr. Reicher. What the do you want? Later.
As per his request, Reicher didn't appear at his own sentencing, which would have really given him something to scream about. He was sentenced to 200 years in a state prison. Reicher appealed the sentence, but it was denied. Next, we head back to the archives, to Jacksonville, Florida. It's 1997, and the defendant is Jason Psycho Stevens. And yes, his nickname is Psycho. He's been charged with first-degree murder, kidnapping, and armed robbery. Just over a month earlier, Stevens and at least 3 accomplices allegedly entered the home of Robert Sparrow and took cash and marijuana from the family. Stevens also took Sparrow's 3-year-old son, Robert. Later that afternoon, he allegedly ditched the car, leaving little Robert locked inside during an 80-degree day. Robert was found dead later that night. Police captured Stevens. He was charged with first-degree murder and a number of other crimes. The prosecution argued that Stevens strangled the child before fleeing, while the defendant claimed he left the boy in the car alive. He pled not guilty to the murder charge. Today, Stevens is making his first court appearance before a gallery packed with devastated family members of the victim. As Stevens signs some paperwork, one man sees an opportunity. That's Robert Sparrow, the victim's father. Apparently, Sparrow had become enraged by Stevens' casual demeanor since his arrest. Joining Sparrow in the attack is the victim's godfather, Lorenzo Houston. Bailiffs charge in and quickly move both men from the scene. Meanwhile, tempers continue to flare between Stevens and family members of the victim. For their surprise attack on Stevens, both Sparrow and Houston are arrested and charged with battery. Sparrow was released on his own recognizance and apologized to the court. Charges against Houston were also dropped. As for Stevens, his case goes to trial, and after hearing the evidence, the jury returns with a verdict.
Find your defendant guilty of murder in the first degree.
He was also found guilty of burglary and kidnapping and sentenced to death by the electric chair. He currently sits on Florida's death row. Next, we head to Clark County, Washington for a bond hearing. The defendant is Christopher Aleo. He's charged with second-degree child abuse and fourth-degree domestic violence. The defendant allegedly grabbed his 12-year-old son by the neck until he couldn't breathe and repeatedly hit him with a closed fist. The boy's grandmother witnessed the incident, and when she tried to intervene, Aleo allegedly threw a playpen, hitting her in the face. Aleo's no stranger to the courtroom, the prison, having recently served a 5-year term for vehicular homicide. In that case, an intoxicated Aleo crashed his car into a light pole, killing his friend Veronica Martin. Now, back in court, Aleo stands before Judge John Fairgrave. When the judge announces bail of $50,000, Aleo's hit with the reality he's going back to jail.
Getting back in the system, man. 10 freaking months, man. You're doing good. Hey, I got right back in the system.
Sensing Aleo's increasing rage, a deputy steps in. It takes 2 officers to restrain Aleo, who receives some advice from a female friend.
No, people. These people, man. You guys got those people over there that on drugs and that keep getting no help, man. No, man.
Once in custody, officers take no chances, shackling Aleo in a wheelchair as they bring him to jail. On his way out, he has a few words for the cameras.
Thinking of mockery of the church in that prison. Assault of a child.
Aleo eventually pleaded guilty and was sentenced to 30 months in a state prison.
All right, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Next, we go to Tampa, Florida, for the case against Luis Angel Lopez. He was charged with burglary and grand theft after allegedly breaking into a home to steal a TV. The case was originally headed for trial, but Lopez agreed to accept a plea deal. Instead of a possible prison term of 15 to 20 years, he's agreed to a maximum sentence of 5 years plus probation. The presiding judge is Michael Williams.
Yes, sir, I am ready to take it. I don't want to make this any worse. I'm ready to get it over with and come out and start a new life. Yeah, I got people that love me, so.
As part of your plea, if you don't turn yourself in by 5 p.m., your guilty plea is going to stand, but not the plea agreement. Do you understand that?
Yes, sir.
Things seem to be moving smoothly as the judge goes over a few questions.
Did anybody threaten or coerce you to enter this plea or promise you anything other than what's contained in the plea agreement?
No.
Are you under the influence of any drugs, alcohol, or medication that would prevent you from understanding today's proceedings?
I mean, I smoke a little marijuana, but I understand the proceedings.
Not exactly what a judge wants to hear from a defendant.
When's the last time you smoked?
Maybe like 30 minutes ago.
Wonderful.
But I mean, I can take the plea. I'm in the right state of mind to
I'm going to be dead before I take your plea.
Though frustrated, Judge Williams remains calm and poses another question.
Is it possible for you not to smoke 30 minutes before you take a plea?
No, I was just nervous that I'm going in, so I was just smoking.
The defendant may be feeling mellow, but the judge is anything but.
I'm about ready to reject your plea and go to trial, just so you know. You can roll the dice with the jury.
Buzzkill.
How do you think it looks to an appellate court that you smoked marijuana 30 minutes before taking your plea?
Bad.
Yeah, that's the legal term.
It looks like Lopez could be losing his deal. But of all people, the prosecutor, Nathaniel Mendoza, suggests a remedy.
I don't know if you'd be comfortable, but I know that NHTSA states that marijuana can impair driving performance for up to 3 hours. I don't know if that would mean that he'd be okay by this afternoon. If his head would be clear. All I got for you.
You may be right, Mr. Mendoza. All right.
Instead, Lopez catches a break, and the judge allows him a second hearing, but with one minor stipulation.
All right, I need you to show up for court and not smoke marijuana right before you get on Zoom. You understand?
Yes, sir.
Lopez eventually appeared sober and accepted the plea deal he was offered. 5 years in prison plus 3 years probation. He was also required to pay a restitution fee of $300.
It's not good for your lungs.
Sure.
This isn't about being very...
Next, we head to Kent County, Michigan, where the defendants are Seth Welch and his wife, Tatiana Fusari. The couple are charged with the murder of their 10-month-old baby. The parents found Mary in her crib at 10 a.m., unresponsive and not breathing. She'd been out for 19 hours before they decided to check on her. Tatiana attempted CPR, but it was no use. Instead of calling paramedics, Seth called his attorney. He also went online to try selling a goat. It was 90 minutes later when he finally called 911.
How long ago did you find the child?
It's about an hour and a half. I called my lawyer first thing to ask, what's the next thing I could do.
So you found the child an hour and a half ago?
Yeah.
And called your lawyer first, correct?
Yeah.
When you found her, she was already believed to be deceased, right?
Yeah.
Do you believe she was beyond help already?
Oh, yeah. It was dead at the door.
An autopsy revealed that Mary died from dehydration and malnourishment, and at the time of her death, the 10-month-old weighed just 8 pounds. The infant was underweight for some time, but the couple refused to take Mary to a pediatrician because they didn't trust the medical profession, and it went against their religious beliefs. Here's one of the many videos Welch posted on the internet sharing his beliefs and theories.
I'm not opposed to medicine or doctors. I'm opposed to bad medicine and doctors that are just, that aren't really doctors. They're priests of the medical cult. They have a certificate from some training camp somewhere that says, they got this test score, but that doesn't mean that they know, about the human body and stuff like that.
The couple were both charged in Mary's death, and at this preliminary hearing, they learned the potential consequences of their actions.
Both charged with what they call felony murder, while in the perpetration or attempted perpetration of child abuse in the first degree, they're alleging that you murdered one Mary Welch. That is a charge called homicide felony murder. It is life without parole. The second offense that you're both charged with is called child abuse in the first degree. It is life without parole.
Both defendants appeared stunned by the severe potential penalties they could face. Later at their probable cause hearing, Seth's cold and callous 911 call was played for Judge Sarah Smolensky.
Do you believe she was beyond help already?
Oh, yeah. It was dead at the door now.
How are you born up?
Yeah, it's another day, right? It just is what it is.
It was not intentional.
The child was skinny, but not sickly. They were breastfeeding the child. These two young people are not nutritionists. They're not dietitians.
But the judge ruled there was enough evidence to send the case to trial.
This baby did not die because of one missed meal. This is weeks and weeks. This isn't about being very skinny. This is about being dead.
Welch pursued an insanity defense. It took the jury only 1 hour to reach a verdict.
On the count of felony murder, count 1, guilty of felony murder as charged. On count 2, guilty of first-degree child abuse as charged. Was this and is this your verdict?
Yes.
Seth Welch was sentenced to life in prison with no chance of parole. As for Tatiana Fusari, she initially pleaded no contest, but then withdrew the plea. She's sitting in jail awaiting trial, but if found guilty, she could also receive life in prison with no chance of parole.
I would ask the court to give me enough time to finish my argument and not to cut me off.
That's former Brigham Young University professor Tom Lowry in a district courtroom in Salt Lake City, Utah. He's representing himself today in a suit against his former employer, BYU, claiming that the university wrongfully terminated him and slandered him, causing his stress-induced mental illness. The university claims Lowry was let go when a part-time vocational program he was leading failed. BYU countered with a motion to dismiss the lawsuit, but Lowry won't be ignored.
Of these factors renders this case closely analogous to the complaint in Hansen, which is.
All right.
I'm almost finished, and please don't interrupt me.
I'm going to take this man into custody and cool him off.
I'm cooled off. I deserve to be heard. I deserve to be heard, Your Honor, and you are violating my access to due process at this very moment, and this better be on the record. I am not violent. And boy, we're going to take you into the police.
Take this man into custody and cool him off.
I'm cooled off.
Lowry's behavior, however, suggests he's anything but cooled off, and Judge Anthony Quinn sends in the deputies.
And this better be on the record.
It's on.
I am not violent.
Him in the back.
We're going to take you into the police.
Lowry's eventually helped from the floor and dragged out of the courtroom.
We'll be in recess.
Lowry's lawsuit against Brigham Young University was later dismissed. He would later go on to file a federal lawsuit against Judge Quinn, the Utah 3rd District Court, and the state of Utah for what he claimed were discriminatory proceedings under the Americans with Disabilities Act. That suit was also dismissed. That's it for this edition of Court Cam. I'm Dan Abrams. Thanks for watching.